Hey guys, so today I thought I would sit down and talk specifically about knitting and crochet and fiber art and copyright law. Now, I'm not a lawyer, but I have done a lot of research in this subject, and I'll share that story later on. I'm going to make this kind of like a series. But today I just wanted to talk in general about copyright law in regards to creating knitting and crochet patterns. So I will leave links down below when I'm talking about this to specific parts of the law from the copyright.gov website. And I would like to say what I'm talking about pertains to copyright law in the United States. Since I live and work in the USA, I haven't researched other countries, but maybe you can find other videos out there from other knitters or crochet artists who live there. But what I'm talking about pertains to the USA. And my second disclaimer is that laws are always changing, so as I'm speaking right now, someone could be changing the law, but this is just what I've learned up to this point, and I don't know if it will change. If it does, I'll try to make an update video, but for right now, this is just what I've learned about copyrights, knitting, and crochet. So knitting and crochet patterns are considered works of visual art by the U.S. Copyright Office, and this just shows that patterns may qualify for protection as visual art pieces. The Circular 31 of the U.S. Copyright Office says that copyright is not available for procedures of making, doing, or creating things. So, like lists, like let's say I made a recipe, and I said you need apples, oranges, bananas, pickles, and strawberries for this recipe. That would be a really weird recipe. Anyway, my list of ingredients is not available for copyright. It's just a list of ingredients. However, my pictures, like my description that I write out about how to put everything together is copyright. Any visual images, video images are mine to be copywritten. And the same goes for a pattern. So when I make a crochet or knitting pattern, any pictures I take, some of my steps will be copywritten, not the broad terms. For example, I can't copyright knit to, purl to for ribbing, because that's just a general basic terminology of knitting. But I can copyright the way I put it all together in my pattern to a certain degree. So what we've established so far is that when I make a knitting or a crochet pattern, it does get its own copyright under U.S. law. I don't have to fill out any paperwork or do anything. It's just when I create a work, it is copywritten. My pictures and descriptions are part of that copy work. However, the general way of doing things and any lists I have in there do not fall under the copyright. So, for example, if I say you need 2 skeins of yarn and these kinds of needles, that's not copywritten. However, you can't publish my pattern somewhere because it includes my visual images and my exact words and how I set it, unless I state that in the pattern and put it under a free use. The second thing that I see a lot of knitters and crocheters in the US doing is they put a little disclaimer down in the part of their pattern that say, if you create something, you can't sell it. And that is just not part of copyright law. Copyright law does not extend to useful articles like clothing, blankets, shirts, and everything. If I create something from someone's pattern, that's my creation, and I can sell that and do what I want with it. I can't sell that person's pattern. I can't sell any of their pictures or use any of their pictures, but I can sell, you know, this scarf that I made. And even if someone else created the pattern. I would like to point out that there's no precedent yet in this matter. So there hasn't been a case where this has come up in court. This is just me reading and interpreting the laws that say that this piece that I created I can sell, even if the person in the pattern who I legally downloaded and made, I can sell it. Okay, so my third point, and I'm sorry if I'm all over the place, this is like headcanon, is the biggest infringement of copyright is creating something that's licensed by someone else. For example, if I create Mickey Mouse gloves or Doctor Who gloves, or those names and characters are licensed by other countries, TV shows, things like that, and technically you're not supposed to do that. So if I created Doctor Who gloves, I would probably call them police box gloves, because a police box is not licensed or anything like that, but Doctor Who or the TARDIS, those tag words are licensed. For example, I recently learned that when I created my Totoro pattern, Totoro is licensed, and I should not do that. And I didn't know that. So technically that was illegal, which is kind of scary. Now I just created a pattern to create the Totoro piece. I'm not selling the Totoro piece, which would be even more illegal. There's a line about creating art in reverence of other things. For example, kind of like writers will create spin-off series about characters in books, like fan fiction and fan art and stuff. And there is a section of the law to allow that. So for example, I would call my Totoro mitts and Totoro hat fan art, but I couldn't sell the pattern, and I don't sell the pattern, it's free, so that falls under the law, and I don't sell the finished work, which would be illegal because Totoro belongs to Miyazaki. So there is a subsection in there for fan art, but the law is kind of shady. Like, I could still get in trouble for creating these Totoro things because Totoro belongs to that company and only they are allowed to promote and create things for Totoro, and I don't have a license from them allowing me to do that. Which is why now I avoid making anything that already has a character attached to it unless I can rename it, for example, TARDIS Police Box. But I do believe that if I was somehow sued, which I don't think I will be, I could say it was fan art and just show documentation that I never made any money from any of these creations that I have created, and nor was I creating these with the intention to make money. But as I said before, the law is shady on that. And at first I was really bummed about this because I love Totoro. Like, he's like my favorite thing, and my whole nursery for my son is created around Totoro. But then I thought about it. What if I created a character? Like, I'm writing a book and I created a space station. What if this space station, everyone really liked it and they thought it was really awesome, and suddenly someone came out a line of t-shirts with my space station on it, and someone started creating hats with my space station on it, and I wasn't getting any of that money or any of the link backs to that. Sure, it would mean that my space station was really popular and people liked it a lot and stuff, but it would also, I made that space station and I deserve that credit. So Miyazaki made Totoro, and he deserves any money that comes from the selling of Totoro type things, unless, I know Disney owns a license to sell Totoro and sell his films too, but they paid a lot for that license, and I'm sure they did. So technically, if I was to create a Totoro hat and start selling them on Etsy or something, I would be stealing from that company. And that's the way I had to start thinking about it. That's why copyright law is really confusing and vague, and it's definitely something that you need to be aware of if you're going to be creating and marketing anything to anybody, because there are nuances out there in the law, and you can get yourself in a lot of trouble really fast. So that's all I'm going to say for this video. It's already pretty long, but I plan on making some more series about this subject.